May 1991, 19-year-old Tammy gave birth to her first child, Kenneth. Kenneth suffered from a number of serious health issues including asthma, pneumonia and epilepsy. The latter condition caused frequent and extremely severe seizures which saw Kenneth hospitalized several times over the course of his short life. Kenneth's death and autopsy. On the afternoon of the 9th of October, 1993, Tammy went to check on Kenneth, then 2.5 years old, who was napping on the bed in their spare bedroom. She thought she had heard him calling her. When she got to the bedroom, she found Kenneth tangled in sheets, gasping for breath and in obvious distress. She tried, unsuccessfully, to free him, before calling for an ambulance. The 911 operator instructed her to perform CPR, but she was unable to calm herself sufficiently to follow the instructions. The emergency crews arrived and took Kenneth to hospital, where he was revived, but tragically, the doctors determined that he had suffered irreparable brain damage. 3 days later, Kenneth was taken off life support and passed away. Tammy gave permission for his viable organs to be harvested for donation, as she hoped that her tragedy could prevent other parents from suffering a similar loss. In 1993, Charles Smith was the leading expert in Canada on criminally suspicious pediatric deaths. He was the director of the Ontario Pediatric Forensic Pathology Unit at Sick Kids Hospital in Toronto, and frequently lectured on pediatric forensic pathology to Crown Counsel, police officers and coroners. He was tasked with performing Kenneth's autopsy. Smith concluded that Kenneth's death was not accidental and, on the 23rd of November, 1993, less than 2 months after losing Kenneth, Tammy was arrested and charged with the second-degree murder of her son. Tammy was tried by judge and jury in Whitby, Ontario. Smith testified that Kenneth's cause of death was asphyxia and surmised that his death was as a result of him being strangled or smothered. Smith's testimony was central to the prosecution's theory that Tammy had suffocated her son in a moment of frustration. In the eyes of the Crown, Tammy was a young mother with limited financial resources, parenting and coping skills, who was involved in an unstable relationship with Kenneth's stepfather. Smith pointed to petechial hemorrhages, small red spots on the organs and tissues that had not been donated, as proof of this theory. The Crown further relied on the testimony of several children's aid workers to lend circumstantial support to Smith's conclusion. Tammy testified in her own defense and insisted that she was innocent, a position she unwaveringly maintained throughout her ordeal. The defense argued that Kenneth had died during an epileptic seizure, but they called no medical expert of their own to support this theory. Perhaps not surprisingly, the jury accepted the Crown's theory, and, on the 24th of October, 1995, Tammy was convicted of Kenneth's murder. She was sentenced to life in prison without the possibility of parole for 10 years. Tammy appealed her conviction to the Ontario Court of Appeal. On the 22nd of January, 1998, her appeal was dismissed by a unanimous court. Since Legal Aid Ontario refused to provide her with further funding, she was not able to make an application for leave to appeal to the Supreme Court of Canada. Having lost her son and her case, Tammy languished in prison. Aidwick and Tammy's exoneration. As early as 1991, concerns were voiced regarding Smith's professional competence. That year, trial judge Justice Dunn acquitted a 12-year-old girl who had been charged with manslaughter following the death of the 16-month-old child she was babysitting. Justice Dunn was critical of Smith's evidence, methodology and conclusion. Throughout the late 1990s and early 2000s, Smith continued to garner negative attention, though given what is now known about Smith's reign of terror during these years, in retrospect the complaints were relatively few and far between. In February 2003, the Association in Defense of the Wrongly Convicted, ADWIC, wrote to the Crown Law Office Criminal of Ontario's Ministry of the Attorney General, requesting the release of autopsy materials from another of Smith's patients for their work on the William Mullis Johnson case. ADWIC soon grew suspicious of Smith's conclusions in other cases as well. In 2004, Tammy applied to ADWIC for help with her case. In April 2005, ADWIC wrote to Dr. Barry McLellan, then the Chief Coroner for Ontario, and Michael Bryant, then the Attorney General, urging a full public inquiry into Smith's work. On 7 June 2005, Dr. McLellan announced in a press release that a formal review would be conducted of criminally suspicious child deaths for which Smith had performed the autopsy. By this time, Tammy had spent over a decade in prison. As part of the Chief Coroner's review, the precursor to the later and broader inquiry into pediatric forensic pathology in Ontario, commonly referred to as the Gudge Inquiry, Dr. Pekka Sorkko, a professor of forensic medicine at the University of Turku, Finland, was assigned to review Kenneth's case. In his October 2007 report to the Chief Coroner, Dr. Sorkko concluded that Smith's finding of asphyxia was illogical and completely against scientific evidence-based reasoning. He found that there is not sufficient evidence for the diagnosis of asphyxia to be made. It cannot be based only on petechial hemorrhages, the red spots of thymus, pulmonary pleura and epicardium, which are non-specific findings. The cause of death should be given as unascertained. Later at the Gudge Inquiry, Dr. Sorkko testified that the evidence that Smith had given at Tammy's preliminary inquiry and trial was unprofessional and misleading. In 2008, Dr. Simon Avis, the chief medical examiner for the province of Newfoundland, conducted a second comprehensive review of the medical evidence and circumstances surrounding Kenneth's death. In his report, Dr. Avis agreed that Smith had wrongly attributed Kenneth's death to homicidal asphyxia and concluded that Kenneth may have died during an epileptic seizure or from other natural causes. While Smith stated that the harvesting of several of Kenneth's organs prior to autopsy was merely a minor inconvenience, both Dr. Avis and Dr. Sorkko were critical of this fact. On 10 February 2009, ADWIC brought an application for leave to appeal Tammy's case to the Supreme Court of Canada, along with the necessary application for an extension of time to file said appeal. The following day, the request for an extension of time was granted and, on 12 March 2009, Tammy was released from the Grand Valley Institution for Women in Kitchener, Ontario, pending the decision on her application for leave to appeal to the Supreme Court of Canada. She had spent nearly 14 years in prison. On 30 April 2009, the Supreme Court of Canada issued an order remanding the case to the Court of Appeal for Ontario for consideration of the fresh evidence and a determination of whether Tammy's conviction constituted a miscarriage of justice. This process took 2 years. But on 7 June 2011, the Ontario Court of Appeal quashed her conviction and ordered that a new trial commence on 10 February 2012. Before the new trial could begin, however, the Crown withdrew the charges against Tammy. That decision was no doubt based on the fresh medical evidence provided by experts, the Dr. Avis, and Dr. Christopher Milroy, an expert retained by the Crown. Both agreed that sudden unexpected death in epilepsy, SUDEP, could not be ruled out as the cause of death in Kenneth's case. Furthermore, Dr. Avis suggested 2 additional alternative natural causes for Kenneth's death, both well-known causes of sudden deaths in infants and children due to inborn errors of metabolism. These 2 alternative causes are known as medium-chain acylcodehydrogenase, MCAD, deficiency and cardiac conduction defects. The causes of Tammy's wrongful conviction. Clearly, the overriding cause of Tammy's wrongful conviction was the evidence of Charles Smith. As Commissioner Gudge put it, Smith had neither formal forensic pathology training nor board certification in that field. In short, he was a pediatric pathologist, not a forensic pathologist. In addition to being unqualified to do the autopsy work on which he spent so much time, Smith was a terrible expert witness. He consistently gave misleading statements and, at times, told outright lies on the witness stand. The reader is encouraged to view Commissioner Gudge's report in its entirety. If not for Charles Smith, it is unlikely that Tammy would have spent almost 14 years in prison for a crime that never happened. That said, there were other factors that contributed to her wrongful conviction. The jury heard a considerable amount of evidence regarding her demeanor at the hospital, Kenneth's funeral and upon her arrest. If this unreliable evidence were led at a trial today, it would likely be ruled inadmissible. While the trial judge instructed the jury not to place any weight on this evidence concerning the appropriateness of Tammy's emotional reaction, the fact is that they heard countless witnesses recount and opine on how an innocent, grieving mother should react to losing a child. Further, the fact that the defense did not call its own medical expert to testify at trial in support of their theory that Kenneth had died as a result of an epileptic seizure was problematic. Legal Aid Ontario's refusal to fund an appeal to the Supreme Court of Canada also cannot be ignored. Tammy's wrongful conviction, like all wrongful convictions, had multiple causes. Most people cannot imagine the pain not only of losing a child, but also of having that pain unbearably compounded by an arrest, trial and wrongful conviction for his murder. Tammy experienced it all and spent 13 years in prison for a crime that did not happen. Though nothing can bring Kenneth back or restore the years that Tammy lost, Adwick fought for Tammy as it does for all its clients, and the truth of her innocence was revealed. Tammy Marquardt walked out of the Oshawa courthouse and into the warm sunshine of a Tuesday morning, strode to a bank of microphones, and smiled. "I'm free," she told a cluster of reporters gathered outside the Bond Street building. "I am free." Moments earlier, Superior Court Justice Michael Brown had offered an apology to the 38-year-old Miss Marquardt, who spent more than 13 years in prison after being wrongfully convicted of the murder of her toddler son, Kenneth. "I offer to you, Miss Marquardt, my deepest expression of regret," Justice Brown said. "Your conviction in this case constituted a miscarriage of justice." Tuesday's proceedings brought to an end a 17-year legal odyssey that began in October of 1993, when Miss Marquardt found Kenneth, 2.5, tangled in his bedding and having difficulty breathing. She placed a frantic call to 911. Charles Smith, at that time the leading forensic pathologist in the province, concluded after an autopsy that Kenneth had died of asphyxia from either smothering or strangulation. Miss Marquardt was convicted of second-degree murder in 1995 and sentenced to life with a minimum of 10 years before parole eligibility. Her case was among several reviewed as part of an examination of the work of Mr. Smith, who was found to have committed errors that led to wrongful convictions in numerous cases involving the deaths of children. New evidence that Kenneth's death may have been linked to epilepsy led the Ontario Court of Appeal earlier this year to set aside the conviction and order a new trial. Durham Crown Attorney Greg Driscoll said that in light of Mr. Smith's flawed evidence and the fresh evidence of Kenneth's cause of death, no new trial would be pursued. Miss Marquardt's lawyer, James Lockyer, said the case had been mishandled from the start. While Kenneth was being transferred from Durham to the Hospital for Sick Children in Toronto, police detained the young mother for interrogation, he said. The criminal case against her was built on the faulty findings of the now disgraced Charles Smith. Tammy Marquardt was essentially an easy target, Mr. Lockyer said. She was an easy target for Smith and she turned into an easy target for the justice system. At the end, justice was served and she walks out of prison as a free woman. Thank you for watching Fathers on the Case. Please like and subscribe.